over the years, there have been major changes in the laws relating to committals, and in Australia in particular, we have a test on the evidence that's used by magistrates at committal that effectively makes it a rare case that gets tossed out at a committal hearing. Most cases get passed on to the higher court for trial, where we run committal hearings, knowing that the case will go to an eventual trial, or likely to go to an eventual trial. We do so with a view to establishing evidence on record that can be used in that person's defence later at trial. Here at this firm, we've often used committal hearings over the years very effectively as part of our case management strategy. We've often used subpoenas to have third parties bring records and documents to court that become exhibits that we then use in the person's defence later. We've often made applications to cross-examine witnesses at committal hearing where we think that has a forensic purpose to help the defendant. For instance, I had a case involving a glassing in a nightclub, where the evidence of the various security staff in the nightclub tended to identify my client as being the perpetrator of the act, but in a way that made it sound like it was premeditated. And in fact, through cross-examining those witnesses, it became apparent that they had put their heads together and then tangled up their own stories such that it was exposed through that committal hearing process. So it was very valuable in demonstrating that our client had a good defence to the charge. Ultimately, at a trial, he was found not guilty by a jury, and that was I put that down to the way we conducted the committal hearing. Committal hearings in the old days, when I say go back 5-6 years, occurred more frequently. Individual defendants had a right to have witnesses cross-examined. There were changes to the law back in 2010 that now take away that absolute right to cross-examine. And if you want to cross-examine witnesses at committals, you must apply to a magistrate for permission to cross-examine or leave to cross-examine. In doing that, you've got to demonstrate why it is in the interests of justice for you to cross-examine these witnesses, and furthermore, you've got to identify the topic areas that you want to question them about. Now, go back to the previous regime about committals, you never had to do that, which meant that you didn't have to disclose ahead of time what you were doing with your cross-examination. Now you do. And I think most criminal lawyers think twice about applying to cross-examine because they're concerned about about how giving up that element of disclosure of your case might affect your client's prospects in the long run. So it's quite a tricky calculation I think a criminal lawyer, defence lawyer makes these days. Do they apply to cross-examine witnesses or not? What are the pluses and minuses? If it's going to be something that will lead to important evidence that's essential for your client's defence, then I think you go ahead with it. If it's not that important, you think twice and you may not go ahead with an application to cross-examine witnesses. The whole process now is quite complex compared to what it used to be, and there's a lot more we've got to think about and consider when we're developing the strategy at the committal stage.